Elliott Blumberg on behalf of Mr. Fennell, who's appearing via Zoom from my office. Judge, this is our motion to strike the plaintiff's objection to the front of the court's recommendation dated January 22nd of 2025. I don't know that you've had an opportunity to review the motion itself.
I have.
Okay, well then, you know, the 46th Circuit Court has been pretty strict in terms of filing objections and making specific findings or objections to the findings made by the referee. And generally, only those matters get heard on de novo review. Ms. Crow, on the 21st day of the objection period, hand wrote and filed an objection that didn't address any of the findings made by referee legal, but rather attempted to explain her situation. I don't even know if she's present here today. She has not filed a response to my motion. We would respectfully ask the court to dismiss the objection.
All right, I do see Ms. Crow here present today, so I'm going to give her an opportunity to explain what it is that she is objecting to. Ms. Crow, this is your opportunity. Please go ahead.
Your Honor, I have had my son for the last 3 years, since the day that we got him back from CPS. His dad went into jail February 21st of 2023 for aggravated assault on a 17-year-old, which I gained full custody of my child at that moment. He got out in December. The reason why the judge was going to give Jason custody is because I live with my parents and the situation is volatile. During the period from the ejection, the reason why it took so long to file is because I worked 56 hours a week at Wendy's. Since court, I have acquired 3 more jobs. I start at Burger King orientation on Monday. I start orientation for KFC on Wednesday, and then Jimmy John's wants to start me on Friday. I'm just trying to see which job has the best hours and better pay. I have $2,000 coming for my own place when my taxes hit. They've been accepted. I'm just waiting for them to hit within the week or two. And I'm getting $2,100. I am getting a car and my own place as soon as those taxes hit. I've already talked to Tom Serino. My son is doing amazing in school. He is for kindergartner that is sitting at a 1st grade level. He has severe separation anxiety. It's to the point where on days that he comes back from his dad's, he's really clingy. He whines and cries a lot on those days. Days that he goes to his dad's, he's a little apprehensive in the mornings. It's hard to get him up. But I don't mind having 50-50 custody with his father. It's just the fact that I've had him for the last 3 years, and they're trying to take him from me completely and give him directly to his father. I have been his only constant. And the fact that his dad got out of jail for aggravated assault on a minor, that's very concerning.
All right, I appreciate all of that information. However, here's the problem that I have, and it's what Mr. Blumberg has stated in his objection, or in his motion to strike, which is, I need to know which or what you object to, not the facts of what you want to add to that. But I need to know what parts of the referee's decision do you disagree with specifically? So you've told me all of the information that you have, but you've not told me where that goes.
Okay, so I object to the fact of me getting every other weekend with my child after having him for 3 years. And I object to Jason getting full custody. I believe that it should be 50-50. Me and
all right, go ahead. Finish your thoughts.
Me and Jason have been communicating through a parenting app, Close, that was court ordered. I talked to Shasta Crouch yesterday about possibly filing either a PPO or harassment charges, because even on the Close app, he is very derogatory and rude and mean, to the point where it's not even about the child anymore. It's about past grudges.
Ms. Crowe, you're once again veering off from the question that I asked. So you object to the full custody decision, and the other objection that you had was what again?
To me only getting my child every other weekend after having him for 3 years.
All right. What you are objecting to is the end decision, the conclusion that the referee made. The referee made that conclusion based on a number of factors that he had to determine, which are called the best interests of the child factors. There's 9 or 10 or 11 of them, depending on how you view the statute. Which of those did you disagree with?
Well, considering my son has been with me, I wasn't able to speak on the bond with my child, because I'm autistic and I'm representing myself. I didn't know that I could ask for a court-appointed attorney on a custody case. I didn't know that I could ask for time to acquire an attorney on my own. I haven't had custody of a child before, and this is new to me. But the fact that I am fighting for my child on my own should say something, for one. For two, the recommendations that I am disagreeing on is during the time of custody with me, there has been numerous issues with Jason himself. There was a court recommendation where he is not allowed to drink around my child, and he violated that court order, where he was stated drinking.
All right,
It just,
ma'am, slow down just a minute. You're getting back into things that, and I know that this is hard for you. I appreciate that, and that's part of the problem with trying to represent yourself, is you don't know what the law asks you to do, so you just want to tell me everything. And I do appreciate that, and I'm being very careful trying to listen to what you tell me. But this is a fairly narrow area of what we're asking, what can be done. The referee had a hearing at which you could have brought up all of the things that you're talking about today. What were you?
to, Your Honor.
I'm not saying I'm not saying you didn't. I'm just saying you had that opportunity. The question isn't, do you agree with the ultimate outcome? The question is, did you have an opportunity to tell the referee all of the same things that you're telling me right now? And it seems to me that you did. Is that true? That you had an opportunity? Not did the referee agree with you, but did you have the opportunity to say all those things already?
Sort of yes, sort of no. When the first case started, it automatically went in to Mr. Bloomberg and him calling witnesses and me having to combat those witnesses. Nobody asked about my bond with the child. Everything that I say that my child tells me or tells counselors or the school, because it's not documented by a counselor, they say it's hearsay. So I could tell you till I'm blue in the face my child is scared to go to his father and he doesn't want to go, but the judge will sit there and tell me it's hearsay. But yet when the child goes to a counselor and the child sits here and tells me to my face that she's lying, that he doesn't believe me. It's not what's in the best interest of the child anymore.
All right, Ms. Crowe, I can't change the rules of evidence. They are what they are. And whether or not you can get certain pieces of information in front of the judge or in front of the referee depends on the rules of evidence. So I can't change that. I can't listen to anything different than what the referee could. I couldn't change how that comes in or doesn't come in. So
I understand.
What you're asking me to do is to change the referee's decision because you're upset that the law doesn't allow you to get certain pieces of information in, and I can't do that. The question I have today is, what specifically do you want to object to? And you've told me the full custody decision and the every other weekend decision. And then I've asked, what evidence did you not have the opportunity to present?
Oh, since court, I have been able to my taxes have been accepted since court. I wasn't able to tell them. I have $2,000 saved in an account as soon as my taxes hit for a place. I wasn't able to tell them, get my bank statements to show them how much money that I'm making at my jobs or my schedule. And at that time, I wasn't able to state on my bond with the child because I was confused on to the questions they were asking.
When was this, the hearing that you had with the referee was in January 22nd of this year, right?
Yes, sir. I did
When-
not get my W-2s until the end of January.
All right, but you would have had an opportunity to tell the referee that you were going to file your taxes and that you were going to use the refund that you received there for housing and transportation purposes, right?
Yes, sir. At that time, I did not. That was my mistake.
And the bond that you had with your child, I assume that you told the referee that you loved your child, right?
Yes, sir. I told him that that child is my whole life. I can't imagine not waking up to that child and getting him up for school every morning. Like, that's my routine. He's my sole purpose. That's why I work so many hours, to try to get us out of here.
All right. Let me ask one final question then. What, if any, other additional live witnesses or new evidence would you have to present at a hearing in front of me?
My cousin, the foster parent, who was the foster parent to my child while he was in foster care, would like to speak on my behalf. I have a school counselor that said she would like to speak on my behalf. And I have a few other people who would like to speak.
And why were those people, the foster parent and the school counselor, why were they not used at the referee hearing?
Because the foster parent, she was downstate dealing with a surgery with her child. And the school counselor, I wasn't able to get a subpoena to because I don't know exactly how to go about getting subpoenas. I'm seeking counsel through Michigan Legal Help.
Your Honor, each of us had ample opportunity to present all the witnesses that we needed to. The child's counselor testified at the referee hearing. Ms. Crow testified at length at the hearing. Again, the fact is that she doesn't and has not made specific objections, and the court has inquired of her, what is she objecting to? And all she can say is she doesn't like the result of the hearing. That's not a basis for a de novo hearing, Judge. I appreciate and again, this isn't the first time she's been in court. She's been in court with all of her children, two of whom her parental rights were taken from, one of which she has no parenting time with. So she is familiar with the court process. She continues to represent herself, and this is the outcome. And so we're asking the court to follow the law as it relates to the court rule and her obligation to file specific objections to the referee's findings, which clearly she has not done.
Objection, Your Honor. So I don't get a hearing because I don't know the specific laws of the court because I'm not a lawyer. That's literally what he's saying. I don't know how to file a subpoena, so I wasn't able to send subpoenas to my witnesses. I was working 56 hours a week, so I wasn't able to file the objection on a timely manner because I'm working. As of my son's father only gets disability. So
Okay,
I have
Ms.
a
Crowe?
full-time job. I wasn't able to file those objections on a timely manner. I represent myself.
Ms. Crowe, are you done now? So I
Yes,
can
sir.
speak? Thank you. You are required, like everybody else is, to know what the law is. There is no lesser amount of knowledge that you get accredited to you simply because you do not take advantage of what the law says that you can. If you represent yourself, you take on the responsibilities of knowing what the law is. It's like driving. You have to know the laws of the road in order to drive, and everyone that drives is assumed to know those laws and is responsible to know those laws. This is no different than that. When you come into court on a child custody, parenting time, or support matter, you are required to know the rules and to follow the rules, just like I am, just like Mr. Blumberg is. Now, I get it that you may have an actual lesser ability because you've not been to law school, you've not been a practicing attorney. I understand all of that, but you're still required. So here are the rules that I have to play by. In order for you to ask for what's called a judicial hearing or a de novo, that is a hearing in front of the judge, the court rule says, to the extent allowed by law, the court may conduct a judicial hearing by review of the referee's the record of the referee hearing. The court must allow the parties to present live testimony at the judicial hearing. However, the court may, in its discretion, prohibit the party from presenting evidence on findings of facts to which no objection was filed. So anything that you didn't specifically object to, that's why Mr. Blumberg asked what you were objecting to, I don't have to give you a chance to have a hearing. Determine that the referee's finding was conclusive as to a fact to which no objection was filed. So if you don't object, that fact is presumed to be proper. And then finally, prohibit a party from introducing new evidence or calling new witnesses unless there is an adequate showing that the evidence was not available at the referee hearing. Simply not subpoenaing someone doesn't mean that that person was not available. Simply because the person was downstate, we could have done a Zoom call, we could have done some other information or other way of getting that information in front of the referee, or you could have asked for an adjournment to make sure that that witness was available to you. So all of the things that you have told me do not fit into these requirements, the laws that I am required to follow. So your objections are just to the results, not to the factual findings of the referee. Your objections are you want to repeat what you told the referee and ask me to make a different decision based on the same type and same quality of information. And that is not what a judicial review is for. The question is there new evidence? There's question is there evidence that was not available to you at the first referee hearing? And I do not find, based on this record, that you have satisfied either of those requirements. So I'm going to deny your request. Mr. Blumberg, would you submit a proposed order?
I will, Judge. Thank you.
Thank you. That's all for today then.
So my question, when does my son have to go to his father? What do I do now?
You send him to his father per the court's order.
The court, or he was supposed to go to his dad for full custody months ago. And he didn't go because of this objection. They told me
Then
not to send him, so.
Mr. Blumberg may file additional requests based on the failure to follow the court's order.
But the court order was he not go to his dad until the objection was over.
So the objection is now over. The objection is now over.
Okay, so I need to know when he goes to his dad's, after the weekend, Monday, when? Like, I don't know. It doesn't say anything in the court order. Do we have to file a new court date to see when he goes? Like, I don't know what to do from here.
This says that the order, the referee's order is that the defendant shall have primary physical custody of the minor child. That means the objection is now done. He needs to have that, needs to go to his dad's.
Cool, so he goes to his dad's tonight then.
That is what the order says, primary physical custody.
Okay, so when do I get my son back then? Because I haven't even got it in a weekend with my son. His dad has had every weekend.
Ma'am, read the court's order. If you have questions about it, you're going to have to get an attorney because I cannot represent you.
Every other weekend. All it says is every other weekend. So which weekend is mine? Is it this weekend or next weekend?
I cannot represent you. I cannot interpret the order for you. You have to get an attorney, or you can call Mr. Blumberg and negotiate
Okay, because
those
this is supposed to be
issues.
my weekend. This is supposed to be my court-ordered weekend, so when does he go to his dad's? On my weekend, or do I not get my weekend?
Ma'am, you just asked the same question again that I previously answered.
Nobody's
I'm not
telling me
going
when
to
my
change.
son goes,
All right.
or when I
Let
get
me
my
ask
time.
Ms.
It doesn't.
Ellison, if you could mute her, please. All right, who else do we have anybody in the queue? All right, this is an objection to the referee's recommended order filed by Mr. Boughner. Mr. Boughner, would you go ahead and state on the record what your objection is to the referee's order?
Yes, Your Honor. My objection was to the amount of child support due to the circumstances of where we're located and stuff. I believe the child support recommendation was $887 a month. Emily Berry and I, she lives in Kentucky and I live in Michigan. I originally allowed her to move when we first kind of had the child. I think he was just under a year old, to the state of Kentucky under the stance of not having child support, knowing that we wouldn't, I mean, we're both young, knowing that we wouldn't be able to afford to, both of us alone, to be able to pay for the child each way. So we agreed to when we each had the child, we'd pay for the child itself. I have no problem paying child support whatsoever. I want to support my son. My son's is my best friend. The only thing I object to it though is, he lives 1,600 miles away from me and I only get him a week. It costs me about almost $400, almost $500 every month just to drive to get him. That's not alone take care of him too. I know it doesn't matter exactly, but I am just asking that the court hopefully maybe lower the amount just a little bit so I can still financially be able to see my son, because once this court order goes in, I will not be able to afford to see my kid. And then another thing that I was curious on, though, is a question. When I filed my, like how much they acquire, like see how much I make a month and stuff, whatnot, on the paperwork it said commission wise, and I put a number for commission. I don't make that every paycheck. That depends on how much work we have, what goes on. So I don't know if that's something that they can be reevaluated, because the amount I put, I believe, was around $300, and I do not make that extra $300 every paycheck that I receive.
And why did you put that number down there?
Because it asked for if I made commission, so I didn't want to lie and say I don't make commission, so I put my average that I received for commission on there.
That's exactly what you should have done, the average.
Okay, that's why I'm asking. I'm not trying to argue, I'm just curious.
No, I appreciate the question. It's a good question, but the average is, sometimes it's more, sometimes it's less.
Correct.
This is what it tends to be, and that's all we can do is make our best guess. Just because you make $50 an hour or $25 an hour or whatever it is today doesn't mean you're going to make that tomorrow, right? Lots of people lose their jobs or you get sick or whatever. So all we can do is say, this is what I'm doing right now. This is the general way that it works. And if something substantially different happens, we can take that into account when it happens. Okay.
Yep.
All right. So let me flip to the child support recommendation. And that is a total of $870 a month in support. Is that correct?
Yes, sir.
All right. And you're telling me that you get the child 1 week out of the month in Michigan, because the child's living with the mother most of the time in Kentucky, right?
Correct, sir.
All right. And you are paying, the reason that mom was allowed to go to Kentucky was a stipulation that you guys entered into back in March of 23, that was then signed by the judge, which said that you were going to let mom and child go to Kentucky. But one of the factors in that was that you would not have to pay child support as a result of that. Is that correct?
Correct, sir.
All right. And so what you're telling me is in order to exercise the parenting time that you're allowed under this agreement, under this court order, is it costs you approximately $400 or $500 to go get him every month, and that's just your transportation costs?
Correct. I'm not, like I said, I'm not trying to not pay anything. I 100% want to support my son. I just don't want to lose the ability not to see him. So, I've tried getting a cheaper vehicle. I mean, I'm 27. I don't have a bunch of money to go spend to get a new vehicle. I drive a Jeep. It costs a lot of money in gas. I make
All
the
right,
trip
so
every single time. And then another
So-
problem too is it's going to get the problem is even if I do get the chance to get him, it's going to be hard to support him because when I get him, I work all week anyway. So I only get to see my son after work. So letting alone paying to support him too while paying all that extra money and then on top of that paying $400 to $500 to get him, it's going to be very hard for me to do. My parenting time would be cut in half because I would have to wait an extra month to be able to afford to see my son.
all right, Mr. Boeckner, as to your work schedule, that's going to be true no matter what happens. You're always going to be working. As adults,
Correct.
that's what we have to do to support ourselves. So we don't have the benefit of when our kids are young of seeing them 24 hours a day because we all have to go to work. So I
Correct.
can't help you with that. What I can maybe help you with is this transportation issue. So I want you to tell me a little bit more about the costs. You told me a general figure of 400 to 500, but it's 1,600 miles. You said you drive a Jeep. What kind of miles per gallon are you getting in your Jeep?
16 to 18 on the highway.
And that's mostly what those miles are between here and Paducah, Kentucky, right?
The 1,600, we meet halfway.
Mm-hmm.
But it's a return
Yes.
trip, so it's down
Yes.
there and back.
Yep. It would take me about 14 to 16 hours of driving. I'd do it in a day.
Do you stay down there at all, or do you make the round
No,
trip all in
sir.
one
I
day?
make the round trip so I can spend more time with my son and my family.
All right, so if we do 1,600 miles at 16 miles to the gallon, that's 100 gallons, right?
Yes.
Times $3 a gallon, that's $300. Maybe a little more, maybe a little less. I think gas is 285 up here right now. I don't know what it is in Lima, Ohio. But even if it was 315, it'd be $315. 350 would be $350. So you're looking at about $350 at most in gas. There's probably a little bit of food in there. So your estimate of $400 is probably fairly accurate in my book.
Yes,
Okay.
sir.
All right. Ms. Berry, do you have any information to dispute his claims of what this transportation is costing him?
I don't know how it's 1,600 miles. So I drive, I believe it's like 394 on the way there and then 394 back.
Which is just under 800, right?
Yes.
Because so, Mr. Is it exactly halfway, or where do you meet at?
We originally meet in Prosperity, Indiana, but this week I had introduced a new meeting spot, so it's possibly easier and it would lower the cost a little bit for both of us. I drive like an extra hour, overall 2 hours, but I drive an extra hour, and I do that because I know she pays more for our son and everything like that. But then I recently just decided, or I made up a new meeting spot that's right off the highway, so I drive like 10 minutes longer, if that even, which I don't mind. But it's
All right,
around
so
the same mileage.
from Gaylord to this new meetings place, one way, how far is it?
It's 6 hours. I live in Atlanta, Michigan, so it adds an extra hour.
All right, so from Atlanta to this place, how many miles is it?
I can tell you exactly. 1 second. I wasn't for sure exactly. Let me tell you exactly. It is 409 miles.
So 800 miles, not 1,600 miles is what you're doing.
No, 1,600 miles monthly. So Saturday I go pick him up.
Oh, pick him up and take him back down. All right, I
Yes.
understand what you're saying now.
Yes, sir.
All right. All right. That sounds appropriate. I mean, Ms. Berry, any other information that you have to dispute what he's telling me now?
I do. I understand where he's coming from. It is expensive to have to meet halfway. However, if you look at the form of the calculations of both of our income, he makes quite a bit more than I do, and I'm still able to afford to take care of our son plus make that trip. So again, I understand that it is a lot, but if I'm able to do it on, a much lower income, then I don't understand how he's not able to. Plus me able to take care of him, our son, the 3 weeks that I have him. Because right now, Mr. Boeckner doesn't contribute to anything that our son needs on a daily basis.
Well, that is the agreement that you reached with him back in 2023, right? You agreed to go down to where you're at now with the understanding that he wouldn't have to, because you get to see your child much more than he does.
Yes, sir. That was at that time. However, a year and a half, 2 years have passed. Our son's getting older, and I want to be able to put him in sports, extracurricular things, and it's hard to do just on my income. So that's why
So,
I'm
so, so you miscalculated on how much it's going to cost you based on an agreement that isn't changing for him.
No, I didn't miscalculate. I think at the time, if I'm being honest, I let my pride get in the way and kind of felt like I could do things kind of on my own. But now the longer that I've lived here and I'm with my son every day, it just doesn't seem fair to me that I have to do all of this by myself when he's more than capable. And I will say that I did file for child support whenever Troy had told me that he has been able to buy a new motorcycle, a new car. He's able to do all of these things. And it upset me because I feel like he should be putting some of that towards his son. And that's really where I came from.
Ma'am, you made a bargain to be able to go where you wanted to go. And now you're trying to renege on it by saying, I don't think it's fair. How is it fair to Mr. Boeckner that he gets less, he continues to have less time with his son because you moved to another state?
Um, can I give you a little backstory on that?
You can. I've read the file. I understand the background, but the court didn't make you make an agreement. You guys
No, yeah.
reached this agreement. And so you're asking to change the agreement on his side without changing the agreement on your side.
May I say
Is
something?
that? Nope. I'm talking to Ms.
Okay, my bad.
Nope, you're all right. I'll give you a chance in a minute. But
Okay.
Ms. Berry, do you understand where I'm coming from?
I do, absolutely. Um, if I can say, I had moved to Michigan for 3 years because I did have a baby with Mr. Boeckner. Um, and I just wanted to simply move back home to Kentucky.
I get
Kentucky's my
that.
home.
I'm not saying you made a bad decision.
Yeah,
Okay. I am not saying that. And I'm not saying that you shouldn't have done what you did. But I am saying that I believe that I have to at least calculate this into the equation because you did make this bargain. Nobody
sure,
forced you to do that. You made it and the court approved it. And now
sure,
you're asking to change it. So I have to, I believe, put that into the equation. So
sure.
again, I'm not throwing stones at you. I'm not saying you did anything wrong. I'm just
Mm-hmm.
saying if you're going to ask to change what the prior court order was, I need to take that into account. All right. Mr.
Sure.
Boeckner, did you have something that you thought was important to say?
Yeah, I had never bought a new vehicle. I wish I could, trust me. But I did get a motorcycle, that is true. But like I said, the reasoning, I think I get where she's coming from about how can she can afford it and I can't. That's understandable. But what I'm getting at is I could afford it now, yes. But once this stipulation goes into contact, like once this child support goes into it, I won't be able to afford it then. Like I said, I'm not saying I don't want to pay anything at all. I'm just trying to get it so where I can still see my son. I just don't want to lose I've already lost so much custody of my son. I don't want to lose any more. It's not even custody. I don't want to lose time with him.
Yep, I understand what you're saying. All right. Ms. Kraus from the friend of the court is here. I'm going to ask her a question that I have. And then maybe I'll factor that into my decision as well. Ms. Kraus, I believe that the child support formula allows for deviation from the formula where it would be unjust or inappropriate. Is that correct?
Correct.
Are there any court cases or rules or policies of the friend of the court that would impact this particular set of circumstances here where we have a very high transportation cost that wasn't part of the original agreement between the parties?
The court can direct us to do anything in regards to the deviation that you feel is appropriate.
All right. It appears to me that the parties originally agreed that, and for good reason, I think Ms. Berry wanted to go back home. And I think that was a good decision that she made at that time. And I'm not going to go into all of the details of why, but I agree with her that that was a good decision. She at that time and Mr. Boughner reached an agreement whereby that would be allowed. There would be no contested hearing, that the parties agreed to that, based at least in part on an understanding that Mr. Boughner would not have to pay child support because he would be receiving much less parenting time in basically a 3-to-1 ratio. She would keep the child for 3 weeks, he would have 1 week, and they would each pay the costs of the child when the child was with them at that time. And so I believe nothing has really changed other than Ms. Berry is now understanding, and it is sometimes hard when you're young to figure out how much is this really going to cost me. So I don't fault her for saying, man, I didn't really understand or realize how much it's going to cost. I think Mr. Boughner is kind of figuring that out too, that it costs.
No, I agree.
It costs more than you really realize. It's a lot to raise a child. So I understand that. I also understand that in approximately the child is now what, 2.5 or 3? 3. So in another year and a half, there's going to be another dispute, possibly, or at least another decision have to be made. Where is the child going to stay as school becomes a priority? And so that's going to have to be figured into the mix. So whatever decision I make today is likely going to get revisited in another year and a half or 2 years at the most. So this is not a forever order. So in my view, I believe that it is appropriate to count the transportation costs that Mr. Boughner has toward the amount of child support. So the current amount that is ordered or would be ordered for child support, I believe, is $897. Let me make sure I got that dollar figure right.
It's 870, Your Honor.
870, excuse me. Thank you. I appreciate that. 870 a month. I believe that Mr. Boughner has legitimately $400 a month in transportation costs. And so I'm going to ask the friend of the court to count those payments that he makes for transportation, that $400, as child support. He needs to document his costs to the friend of the court on a regular basis, so that if they substantially change, if gas goes down to $2 a gallon, I don't think that's going to happen, but if it does, your costs are much less. So on a quarterly basis, I'm going to ask you to submit your documentation to the court, the friend of the court, indicating that how much you've been paying for that. And then that's going to be deducted. So the amount of child support ongoing to Ms. Berry would be $470 a month, which will assist her for the future. And then this can be revisited once a decision is made about where the child is going to stay full-time during the school year. Any questions about that, Mr. Boughner?
Yes, I do. In that child support when they asked, it would pay for his insurance too. Does that go towards that? Because I just want to make sure that's covered for her and him, because I know it is stressful to pay that much, but I know in the original thing, the state of Kentucky had requested that I pay for child support and his insurance. So I just want to make sure.
Do
Go
you
ahead.
have him on your employment insurance now?
No, but they said that the last time when I talked to the referee, I believe he said that it was part of the child support. It was $200, I believe, and $1 for the insurance for him through the state to pay for it, and then the rest was just child support alone. But it was part
Well,
of the thing that Kentucky came after me for.
I think you may be confusing child care with insurance. There is an amount in the that she is asking, that the state of Kentucky was talking about for child care. That is, when she goes to work, she has to have somebody watch the child. And
Okay.
she's saying that your portion of that would be $211 a month.
Okay, that's what that was. Okay,
That's what
then
that is for. There's
my
another part.
apologies.
That's all right. That's a good question. There's another part of the formula that deals with if you are paying for health insurance and you get credited for a portion of that that would go to the child if you are paying for that. If you're not paying for it, it doesn't involve that. But
Okay.
if you do put the child on insurance so that the child is not receiving Medicaid or Medicare or public assistance in that regard, you, Mr. Boughner, or you, Ms. Berry, would get credit for that, and it would change the child support recommendation.
Okay.
Does that make
Thank
sense?
you. Yes, sir.
All right. So I'm going to direct the friend of the court to implement the $400 at transportation costs as a regular part of the child support that you are paying. You are to confirm that you're paying that amount by sending in quarterly statements to the friend of the court indicating that that's the amount that you are paying, and supporting that with documentation. And then, so I'm not going to change the actual amount of child support. It is what it is as recommended, but I'm simply giving you credit for the costs that you normally wouldn't have had under the agreement. I'm count that as child support. Any questions that you have, Mr. Boughner?
Just to get it to fully understand it. So technically they will still, so will they pull the $470 or will they pull the full $870?
They're gonna, if it's gonna come from a withholding order on your check, it's gonna be $470.
Okay. And then
you're gonna show the friend of the court that you're making the other $400 payments by doing those quarterly payment statements.
Okay. And we'll receive paperwork in the mail for this, correct?
Yes, you will. Yes,
Okay.
you will.
Then I'm done.
Ms.
Thank you, Your
Berry?
Honor.
Ms. Berry, any questions that you have?
No, sir.
All right, Ms. Kraus, do you have any questions for me? Because I know you're gonna have to try to put this together on paper for me.
I don't believe so.
All right, thank you very much. That will be the order of the court then. Thank you.
Thank you.
Thank you.
We are here on plaintiff's objection to, plaintiff is Mr. Corby, his objection to the child support recommendation. Mr. Corby, I've received your one-page, I've received your objection to the child support review. It contains an addendum. And I've read all of those, so go ahead and argue your objection, sir.
I just, like it says in my form, I've had full physical custody of my son for 11 years now, and I've paid for all of his medical expenses, dental expenses, sports utility, anything he's ever needed. And, and recently we switched to 50-50 custody and everything's been fine. And throughout the years, I've got minimal child support. I was getting around $125 a month, and I was paying $500 in daycare expenses for the 10 years that, I had the full custody and before he was 12. And, and I just assumed that once we went to 50-50 custody that there wouldn't be any child support because I
know what they say about assumptions, right?
Right. But me and my wife just spent $6,000 for my son's braces and everything else. And I just seems like, we've put in a lot over these years, and for my son to be 13 and now to pay $391 a month just seems like a lot, I guess.
I'm not disputing anything that you've told me. However, I'm only allowed to make changes to things where there's a legal objection. So the only question that I have before me is, did the friend of the court accurately run the child support formula guidelines? And is there some number that they used that was inappropriate? I can't rectify past inequities. I can't change what happened in the past. So I apologize to you for that. I know that it seems in a world of fairness that might be a great argument, but all I can do is look at what is the current set of facts, set of circumstances. Did the friend of the court's office properly apply the formula? And if so, I have to go with that. That's what the law requires me to do. So the fact that you've made all of those payments, I'm taking as absolute truth, but I can't do anything about that. Does that make sense to you?
Yes. Yep.
All right. So go ahead.
Okay.
Any other arguments that you wish to make?
And me and my wife are, we're also homeowners. So, I mean, we have home taxes and home expenses. And, after this winter we're going to have to probably put a new roof on after the ice damage and everything else. It just seems like being homeowners and everything else, we have a lot more expenses maintaining a home than income-based apartment building. Where my electricity is paid for and stuff like that, I guess.
Well, the electricity is paid for by the rental. I mean, that's all in the costs. So we don't, the law doesn't let me say you get so much deductions for certain expenses. It's based on what your income is from both families, both sides of the equation. And as long as the income information is, we don't tell you what kind of house that you have to buy. If you want to go out and buy a very small, tiny house and live in that, that's entirely up to you. If you want to buy a mansion, that's entirely up to you. How you use that income is entirely up to you. And I can't get into changing that. So I recognize that what you're telling me is true, but again, I'm limited in the law by what I can effectively change. And so the question is, did the friend of the court use the guidelines appropriately? And the amount of expenses that you have is not one of those things that they have the ability to view or change.
Okay. Yeah, I guess, and I guess the only thing I can dispute about the income is that in the beginning of December, my son told me that his grandma moved in to Miss Sevener's house. So I feel like that's a change of income. And
the income, the only applicable income is the income of the two parents. It's not it's not the household income. Like if you had someone, a friend of yours or a cousin or someone that made a lot of money move into your home, I could not add their income to yours.
Right. But I mean, Miss Sevener could increase her own income by rejoining the workforce. And,
I can certainly ask the friend of the, I can ask the friend of the court what they use for that. I see a number down here as a gross income. And I believe that was imputed to her or was so, but I'll ask the friend of the court. Ms. Ellison, who should I talk to about that?
That would be me, Your Honor.
All right, Ms. Kraus, can you tell me the income that was used for Ms. Sevener, the $1,417 a month, where did that figure come from?
From Social Security.
And is that the equivalent of full-time work, or is that is there a process by which we could add to that for imputation up to full-time work?
If she has the ability to earn additional income because it's SSDI, she would, but we are not aware if she is able to work at any capacity outside of what she's earning now with that.
All right, so because she's on SSI, she is deemed to be disabled and not able to work, so that you are not able to impute any additional funds. Is that what you're telling me?
Unless she can indicate to us that she is able to earn an additional amount without losing those benefits.
All right, Mr. Corby, does that answer your question?
Yeah. Yep.
All right. Any other objections that you have, sir?
Nope. Nope, not really. I guess none of my arguments really make any, don't have any credible dispute, I guess. So.
Yeah, and I understand your frustration, and I understand where you're coming from, but unfortunately, with this sort of situation, I am limited in what I can do for you, and unfortunately, none of the arguments that you bring forward are going to change what the recommendation is. So I'm going to have to deny your arguments, and we'll go forward with the amount as recommended. If something changes in the future, or if you get additional information, you can always bring that for us again.
Well, and I was just curious. So, do I still have full physical custody of my son?
That has not changed. The child support does not change custody. So all we're here today on is the child support.
Okay, and
So
as far as
order,
my son gets a percentage of Miss Sevener's disability amount, and it goes directly into a savings account for him. Is that going to stop for him, or is that?
nope, that doesn't. This does not change that.
Okay. Okay, I was just curious.
All right. Anything else, sir?
Nope, that pretty much sums it up.
All right. The friend of the court will enter an order. Help me out, Ms. Krause, if I'm incorrect, but the friend of the court will enter an order indicating that the objection has been denied and that the child support amount as recommended will become the order of the court.
Correct.
All right. Thank you very much, Mr. Corby. That's all for today then.
All right, thank you.
This appears to be a request from the friend of the court to show cause. Looks like the last payment was made in June of 2024. The defendant failed to appear in January of 25 for a show cause hearing. And the hearing today is to address his failure to comply with the support enforcement order of October, his non-compliance with that, and the 60 days of jail that have been held in abeyance since October 21 of 2024. So Mr. Fuhst, tell me what you've been doing and why you haven't been making your payments.
I haven't been able to work. My felony is getting in the way.
What stops you from going to McDonald's or Burger King or a gas station or any of those places?
I've applied to everywhere around here. In Gaylord, nobody wants to hire me.
I know of lots of felons. I'm the district court judge. I have felons that appear in front of me all of the time to tell me that they're employed.
This is due to family relations back when I was a kid, and also everybody in this town knows my family.
When was the last time you were employed?
I had to move from finding a job in Otsego County to find one in East Tawas. My last job was Webb's Well Drilling, and that was out of East Tawas.
That tells me where you worked, but not when you worked.
That was back in the summer, fall, before October.
Okay. How are you supporting yourself now?
I'm not. I get food stamps and working with DHS. And I have cases coming up within the next month or so. And at this moment, due to sentencing's April 7th, it's pointless to even work.
What's the sentencing on April 7th for?
East Tawas for a B&E.
So you're not working, but you're committing crimes?
No. This was while I was at work and I'm fighting it.
You just told me you got a
This is the first offense in like 10, 11 years, other than child support stuff.
Well, Mr. Fuhst, the order that was entered in this case back on October the 21st of 2024 found you in contempt and sentenced you to 30 days in jail consecutive to the 15-day jail sentence, and then held an additional 60 days of jail in abeyance, meaning that you've already been sentenced for contempt to go to jail for 60 days, and that's being held pending your performance. And that means your payment of your child support amounts. So since October of 24, have you made any payments?
No, I have not, because I have not been making any money income.
So you are able-bodied, and you last worked at a well drilling place. What stopped you from going back to the well drilling place?
I got arrested at the job for child support, so they fired me. Same
What
with
stopped
my
you from
other
going to another one?
Same with the other 4 jobs that I got fired from.
What
Every
stops
job
you
I
from
get,
going
I get arrested in. I'm sorry for interrupting, Your Honor.
What stops you from finding another similar job?
I'm putting applications in on Indeed. I'm filling out applications online, and nobody's getting back with me. Every time I call, they say job's been filled, not hiring anyone at the moment. Other people say your felony is too extreme for us to hire you. And then right now, with sentencing coming up, I just deemed it not viable to work right now because I'm only a couple weeks away. And if I get a job before the sentencing, it's just going to be pointless. I won't get a paycheck before sentencing. So
you basically decided not to try to get a job because you're going to go to jail in 2 weeks.
yeah,
All right. Then you're going to go
I'm
to
going to
jail
be in another
today.
county.
Then you're going to go to jail today because you've decided to not work, because that's what you've been ordered to already do. You got 60 days of jail pending against you now if you're not going to pay. So you've decided not to pay, so you're going to jail. You understand that?
I got applications filled out. I got like 50 applications filled out in the past week, and nobody's getting back with me. Nobody wants to hire me because of
You've already told me twice, Mr. Fuhst, you've already told me twice that you've decided not to do anything for the next 2 weeks because you're going to jail. So it doesn't make any sense for you to try to get a job.
To a point, it is kind of pointless. I won't get to see the paycheck.
Neither
How
will
am I
your
going to
children.
pay it if I'm?
I didn't say this was going to be easy for you. I just said that there's a responsibility to pay, period. It doesn't matter if it's easy or not. It doesn't matter if it makes a lot of sense or not. It's just a requirement. It's not an optional thing for you to say, I'm not going to do it because it doesn't make any sense to me. It's a duty to pay it. And since you've not done it, since you have the ability as an able-bodied person to get some level of work, I'm going to put you in jail. You can report to the Otsego County Jail at 6 p.m. tonight. You will serve these 60 days there. You'll get credit for, I'm assuming you'll get credit on the next sentence that you get. That's up to that court to deal with that, but you're going to do the 60 days jail here. Once you're released, this requirement for payment still is in existence. It doesn't change. You have to make your payments, which means you need to find a job. It doesn't matter what kind of job it is, as long as you're making a job and paying something, then you stay out of jail. But if you're not going to do anything, you're going to stay in jail. Do you understand that?
Yes, Your Honor.
All right.
I got a question, Your Honor.
Go ahead.
How would I go about putting stuff to courts? Like
I
paperwork
don't
and stuff.
understand what your question is. Be more specific, please. What do
Like
you want to do?
motions and stuff. Would I have
You
to
mail
fill that
them?
out at the clerk's office?
You don't have to. You can mail whatever documentation you want. Online, there are forms that you can use for most of the normal types of cases. If you can't get that online, you could go to either the friend of the court or the clerk's office and ask if they have a form for what you're trying to do. And if not, you can simply write a letter and explain what it is that you want to do and send that in and see what happens.
Okay.
You have any other questions?
No, Your Honor.
All right, if you fail to show up at the jail, there will be a bench warrant for your arrest and the police will come looking for you. Do you understand that?
Yes, Your Honor.
So you have 60 days of jail. Report to the Otsego County Jail, 6 p.m. tonight.
Your
Good luck,
Honor,
sir. Yes.
would it also be appropriate to add upon his release, he can contact the friend of the court moving forward in case he's able to submit job searches and so forth to continue to be compliant with his support orders?
I think that's a good idea. How many job applications per week do you suggest, Ms. Kraus?
Well, he's indicated that he's submitted at least 50 or 60, so I would think 25 a week.
Mr. Fuhst, can you do that?
Yeah, I can do that. I can also submit all these jobs that I've applied to that
Just moving
nobody
forward would be
wants to hire me
appropriate
for.
upon release.
Yep, all you need to do is 25 a week, 25 new ones for each week. Moving forward, that lets the friend of the court know that you're doing what you're supposed to be doing and they don't have to think about whether or not you need to go to jail. So they don't, so that keeps you showing that you're making a good faith effort to make your payments. As long as you're doing that, you're okay with the friend of the court and okay with the court. You understand all of that?
Yeah.
So upon release, 25 job applications a week to the friend of the court. All right, do you understand what you need to do, Mr. Fuhst?
Yes, Your Honor.
All right, that'll be the order of the court. Thank you. Are you Timothy Brewer?
I am, Your Honor.
All right. There are 3 cases that we have with you, all involving child support. And I'm going to call them one at a time just so we can keep a proper record for them. So there's going to be 3 of these processes that we have to go through together, just so that you're aware. We are here on this case, which is the case involving Amanda Lane first, and that's file 2012-14613-DP. Nope, sorry, I've got the wrong one. I think I called the 18 case, so let me get to that one. This is the case involving Mary also Brooks. All right, Mr. Brewer?
Yes.
So that's the 2018 case involving Mary. The allegations in this are that you've already posted a $600 bond in February on this case, and this hearing today is to address the issue of contempt and forfeiture of the bond, and to show cause why you shouldn't be held in contempt for failing to pay the previously ordered support. And there is an arrearage in this case of $1,051.26 as of the paperwork date of February the 14th, I believe, of 25. So tell me why you haven't been making your payments on this case.
Well, I believe I have been making payments. I mean, I make payments at the friend of the court, and I do believe it gets divided equally. I mean, so I have been making payments. I guess I just went through a separation after 8 years, got thrown out of my family home and had to move. So I've had some life, some things going on in life, but I have been trying to make payments. I guess, Your Honor, I do realize they have not been regular. So I do not want to mislead you and think I have made regular payments. So I guess I have missed some payments.
All right. You posted a bond in this case of $600. Do you have any
Yes.
objection? We use that $600 bond towards your arrearages. That would reduce it down from approximately $1,000. 600 off of that would put you down in the $400 range, which would be a little less than your past due amounts or your normal balance that you have to pay.
Your Honor, I have no rejection. I also was going to make a payment today at the friend of the court.
How much would that be?
I was going to pay $100 at least, maybe $150, but for sure $100 payment.
Your Honor,
Yes.
There has been no payments on this case since May of 2022. That amount was $20.14. The defendant does have the 2 additional cases. Partial payments have been made, but they've always been made by a third party. And it's been indicated to them that they were to make him aware to contact us, because depending on how charging cases are and arrearage cases, when monies are not made specifically to a case, they disperse to the charging cases first.
Okay, does that make sense to you, Mr. Brewer?
It does, Your Honor. My understanding was that it was dispersed equal to all accounts, not just accounts that were still charging. So I was misunderstood that.
All right, so we're gonna post the $600 that you've paid previously in a bond. We're gonna forfeit that, and we're gonna set that as a payment in this particular case. When you come into the friend of the court today, Ms. Kraus, does he need to designate the $100 on this particular case? And can he do that? Can he post it to one case?
He would need to be present because there's a voucher that he needs to complete with a signature identifying that that is his request. Otherwise, it will disperse the way that I had just explained.
All right, do you understand that, Mr. Brewer?
I do, Your Honor.
All right, if you're willing to do that, I'm not going to hold you in contempt on this case, because I believe that the $100 payment and the $600 payment shows your good faith in this particular case, so I don't need to hold you in contempt. So by the end of today, 4:30, are you going to be able to get to the friend of the court's office prior to 4:30?
I will be, yes.
All right, so prior to the end of business today, there needs to be a $100 additional payment towards this file. And we'll forfeit that $600 and put that towards your balance in this file as well. All right, Ms. Kraus, do you understand? Yes. Anything else, Ms. Kraus?
Would it be at all appropriate to just request to possibly adjourn this out a month? And if he was to pay the balance in full, we would just dismiss this proceeding. Because I think based on him making the bond payments, there should be no reason that he's not able to pay off the remainder of the balance in the next month.
So with basically it would be $700 today. You would owe about $350 or $351 for the subsequent month.
$351.26. Yep.
Yep. Are you able to do that, Mr. Brewer?
I should be able to, Your Honor. I should be able to. Yes, I can do that. 300. All
right.
Can I get an amount there? Was it again 3?
It would be.
Three.
Oh,
go ahead,
sorry.
Ms. Kraus. Go ahead.
The remaining balance after the bond forfeitures would be $451.26. He indicated he would be paying $100 today. So we would just request that additional $351.26 be paid before the April 23rd hearing in front of you. Does that make sense?
It does to me.
All right, then that's what we'll do. So we'll adjourn this file, the 18-17153 file for a month. We'll forfeit the $600 today. There'll be a $100 payment today, and then there will be a balance of $351.26, was it? Payable within a month.
$351.26.
All right. So next we will call the matter of Mr. Brewer and Amanda Sue Lane. That is 12-14613-DP. In this case, it appears that there has also been a $600 cash performance bond posted. However, the defendant still owes approximately $8,000 in unpaid and past due amounts. There is a current amounts to be paid every month of $372. And this hearing is to address the issue of contempt and forfeiture of the bond. Mr. Brewer, any additional information you want to give me on this case involving Amanda Sue Lane?
I do not believe so, Your Honor. I mean, I obviously have no problem with the bond being forfeited. I also, me and Amanda, we talk often. She had indicated to me that she was going to come in and waive the back child support on this matter.
I am not aware that that's been accomplished or has been done. Ms. Kraus, do you have any information on that?
That has not been done, but there are
Yep.
specific procedures in regards to handling that.
Yeah. And she has done it in the
Paperwork to be
past.
required. All right. Can you make an additional payment over that $600, Mr. Brewer?
Probably not today, Your Honor, but by next Friday I can.
How much would you anticipate there?
I can pay $100 on that one by next Friday. Now, if she comes in and takes the steps to take care of that back child support, could that change? Well, no, because I think I would still owe the state. So that $100 could go towards the states.
That's correct. There are statutory fees of approximately $539, medical support of $748, and additional costs and fees of $300. So we're looking at $1,500 that is probably can't be waived. And again, I'm not requiring her to come in and do anything on those things. That's entirely up to her.
Absolutely. Yep. Absolutely.
So Ms. Kraus, similar to the other case, you want to adjourn this for a month and see if he makes the $100 payment and then comes in, he's going to have to make another $372 payment. Would that be, or what else would you recommend?
We would actually be requesting contempt at the next hearing. We would request a contempt hearing.
Okay, so we just want to adjourn it a month and see if he makes his payments and then go from there?
That would work.
All right. Mr. Brewer, do you have any questions about this case? Basically, we're going to forfeit the $600, require a payment next week of $100 and then adjourn for 1 month and see how whether or not you've made your normal payment of $372. And if you do, typically we would adjourn it again. As long as you're making your payments, well, we wouldn't have any additional problems.
Absolutely.
Ms. Kraus, does that $372 involve any arrearage amount?
It does not. Potentially, we could address, if possible, to request an ordered on arrears of 186, or we could address that at that next hearing.
Why don't you send him a proposal on all 3 of these files as to ordered on arrears amounts and see if there's a way that we can work something out. I don't know what his current income is, and that may need to be a conversation that you have with him as you're determining what that ordered arrears amount is as to what he can afford. But let's do that in the next month, and then when it comes back before me again, he'll at least have some input into that, and we'll be able to decide that at that moment.
Yep, I would request that he contacts our office. It does seem that in prior attempts to contact him, I haven't been successful.
All right, Mr. Brewer, do you understand what I'm asking you to do?
I do, Your Honor.
Contact a friend of the court's office to discuss payments on the arrears.
All right.
And that's what she called an ordered on arrears amount. So that would be your current child support is $372. That would be an amount every month that you would pay in addition to that to start paying on that back amount that you owe. Now, if there's a waiver of that, that can be taken into account because that may lessen it somehow, but there's still going to be those state fees that are there no matter what. So we need to have some payments being made on the arrears amount.
Absolutely.
All right, so that will be the Amanda Lane 2012 file. That will be the order of the court in that one.
Your
Ms.
Honor,
Kraus,
just
anything else?
Yep, just
go
for
ahead.
clarification, if Mr. Brewer and myself do come up to an agreement, would it be appropriate to send an order if that ordered on arrear before then for sign to be placed
Absolutely.
in the file?
I'd be happy to sign that if there's a consent agreement.
Thank you.
And then finally, we're going to hear the matter of Mr. Brewer in file 16-16267-DS. And that is the case involving Heather Ford. In this case, Mr. Brewer owes, looks like $21,098.43 in unpaid and past due amounts. He has a $376 current amount paid. There is a $3,000 performance bond that was posted on February the 12th. So the hearing today is to determine whether or not we should hold him in contempt for failure to pay and whether or not to forfeit the bond. Mr. Brewer, as to this particular case, any additional information that you want to give to me?
Your Honor, no, there isn't. Besides, the only thing I want to say is I spoke with Miss Ford in October. Janie is our daughter together. She's the only daughter I don't see. They're supposed to, she showed me, she has papers. There's supposed to be an adoption. She is supposed to be adopted by her new husband, and that adoption was supposed to be going through. She showed me the paperwork that she had it and had started filling it out. I don't know if the caseworker knows anything of it or what more. I know I have not spoke with her about it since.
All right. If there is an actual adoption, your rights to the child would be terminated, and once an order is entered terminating your rights to the child, then the child support typically would cease concurrent with that court order. And then the friend of the court would be directed to stop on any ongoing child support amounts. The back owed child support, however, would still be owing. It would all be arrears at that point.
Right, which she was saying that she was gonna erase those arrears too when the adoption took place. So, but I obviously realize if none of that's happened yet, until it does, till that paperwork's filed, it's still owed.
Right, and there are still medical and statutory and other costs and fees that would not be available to be waived. So there would still be an amount that you would have to have paying back over time. So it would be important for you to speak with the friend of the court about those. So do you have any objection to the court forfeiting the bond and applying that towards the arrears?
Absolutely not, Your Honor.
All right, so we will do that. Is there any additional amount that you can pay over this next month?
Well, I intend on definitely making $100 payment every Friday for sure. So, I mean, if I need to direct one to that case, I can definitely do so.
I think it would be appropriate to do that.
Okay.
And then you can contact the friend of the court again, just like the other file, and discuss arrears.
Absolutely.
And come up with an amount, hopefully reach an agreement on that amount. Even if you have to come up with some amount just on the statutory arrears and wait, if you can't figure out when the waiver might be, I don't know, but you guys can discuss all of those things and come up with an agreement between yourselves. Ms. Kraus, anything else that you would like to do in this particular case?
Nope. As long as we're able to reach an agreement, then potentially at the next hearing, but if not, we would also be seeking contempt.
All right. So, Mr. Brewer, you understand that you need to get a hold of the friend of the court on all three of these files. You need to make an additional $100 payment sometime this next month on all three of these files. And
Absolutely.
there is the issue of arrears payments that need to start being made. So they need to start looking for an agreement. Now, I'm not going to require you to reach an agreement with the friend of the court, but if you can't, they do have the right to ask for contempt in the next monthly hearing that we have, which will be rescheduled for. All right.
All right.
All right. So we go ahead. Anything else, Mr. Brewer?
No, Your Honor.
So we will forfeit the bonds in all three of these files. We will adjourn 1 month in all three of these files. There will be an additional $100 payment during that during that 1 month adjournment. And you still need to make your normal monthly payments for that as well. And then you guys will work on reaching an agreement in all three of these files as to arrears. All right, I think that resolves all of those cases for this time period. Thank you very much, Mr. Brewer. You're free to go.
You have a good day, Your Honor.
You too. All right, looks like we are here on a motion regarding support filed by Mr. Sanchez. Is that correct?
Yes, sir.
All right, why don't you tell me what it is that you're asking me to do, sir?
Well, Ms. Shackleford and I came to the mutual agreement via text and phone to discontinue our child support. We both spoke about our case with our caseworker, Tara, who advised us to file this motion. And excuse me, my apologies. And that's primarily why I'm trying to follow through with this. Also, we have a son in common, and I speak to him roughly every week, and I don't want to force him to do anything he doesn't want to do. And it doesn't sound like he has any type of desire to come and see me this summer. And like I said, I don't want to force him to do anything. I don't want him angry with me in any shape or form. But it's been so many years since I've seen my son. He's 16, a couple more years before he's 18, and I get the feeling he has no desire to know who I am or understand, what is, really going on.
All right. I understand that the two parties actually had 2 children together. Help me with the name of the daughter, Aomi?
Yes,
Yeah.
Aomi currently lives with me.
And she is now aged out of child support. Is that correct? She's 19?
No, she's 18, but she still currently resides with me. I'm still supporting her.
All right. So is she still in high school, or is she graduated already?
She graduated, sir, but she's looking to
All
better.
right. All right. So in other words, there's no, for child support purposes, once a child has graduated from high school, has turned 18, they typically are an adult, and child support no longer applies. So in that case, we really are only dealing with your son, and that's Isaac, right? That lives with Ms. Shackleford in Oregon.
Yes, I also.
All right. So I understand that. So if I remember correctly, the child support when there was 2 children was something like $36 a month. And then when it changed to 1 child, because that child lived with Ms. Shackleford, the recommendation was that it go up to $271 a month. Am I reading that correctly?
Yes, that's correct.
All right. And so you're telling me that both of you have, because of the circumstances and the years that Isaac has been with Ms. Shackleford in Oregon and has not had any real lengthy contact at all with Mr. Sanchez, that the parties have agreed that child support is not appropriate. Is that true, Mr. Sanchez?
Yes, sir.
All right, Ms. Shackleford, is that true as well?
Yes, sir.
All right. Okay, Ms. Friend of the court, Spillane, is it Ms. Spillane, or did I get the last name wrong?
You got it right.
All right. You have been the worker in this case. Is there anything else that I need to be aware of in making a decision based on their request?
No, sir. They don't have the public assistance. I don't see any reason why there would be any issues. They've both communicated quite clearly with me that this is what they're wanting to do.
All right. So there's no reason that you can think of that I would be required to order child support even over their objection. So there's no public assistance. There's no in our unequal bargaining position. There's no domestic violence. None of those normal red flags that we talk about would apply to this case.
Correct.
All right, based on the parties' agreement and the overall circumstances of this case, I will grant the request to set the child support amount at 0, and I would ask the friend of the court to follow up with an appropriate uniform child support order that sets support at 0. Is there any other circumstances under which we need to have any other kind of court order, Ms. Spillane? Is there anything that needs to be done for medical expenses or anything like that, or so we just allow that to the parties deal with that on their own?
I do see that there is still a partial payment owed for March. If Ms. Shackleford is willing to waive money that's owed to her, we could do that. There's also going to be a very small amount that is owed to the state that Mr. Sanchez will need to take care of for us.
All right, Ms. Shackleford, what do you want to do with any amounts of arrears? Would you be willing to waive those, or do you want to have those paid?
Yeah, those can just be waived.
All right. And Mr. Sanchez, I would love to be able to say you will waive the state fees, but I can't do that. So those will, on your end, those will have to be paid, but you don't have to pay the other arrears. So we'll enter an order that waives the small amount of arrears that are owed. The state of Michigan fees will have to be paid, Mr. Sanchez, but other than that, we'll set the court's order at 0 for child support. I want to thank you both very much. I would hope that you would continue to do as much as you can to allow contact between Isaac and Mr. Sanchez, because I believe having a good relationship between father and son, even if it's long distance, is still a good thing in the long run for both parties. But I'll leave that to your expertise as the parent. So good luck to all of you. We'll enter this order and you'll get copies of it. Thank you, Ms. Spillane.
Thank you, Your Honor.